I'm Ben Meiselas from the MeidasTouch Network. We are on the eve of trial between E. Jean Carroll and Donald Trump. E. Jean Carroll has filed rape and defamation claims against Donald Trump. This is a civil case in federal court before Judge Lewis Kaplan. Trial set to start on April 25th, so trial will begin tomorrow as of the date of this recording. And Donald Trump's lawyer, Joe Tacopina, continues to file these letter briefs with Judge Kaplan that are each just more disgusting and frivolous than the next. And Judge Kaplan, the federal judge presiding over this case, has repeatedly smacked down Tacopina, and in these very kind of tersely worded orders basically says, Tacopina, you don't know what you're talking about. But I guess Tacopina has been hired to just be Donald Trump's bull in the china shop and just continue to file motion after motion after motion, despite the judge's continued orders rejecting these motions. You know, this most recent motion that was filed over this weekend was very disgusting. And in this motion, it relates to one of the witnesses who will be allowed to testify at trial, Natasha Stoynoff. And Natasha Stoynoff is or at the time that's relevant to the case, was a People magazine reporter. And in 2005, she went to Mar-a-Lago to cover Donald Trump's lifestyle with his then pregnant wife, Melania. Melania was 7 months pregnant at the time, and Stoynoff was doing a story about the pregnancy and Donald Trump and Melania's life together. At a certain point in 2005, while that interview was taking place, or shortly thereafter, Donald Trump had Stoynoff go into a room alone with him, and then Stoynoff alleges that Donald Trump lunged at her, tried to kiss her, and tried to grope her. Now, under the federal rules of evidence, somebody who engages in sexual assault, in a case involving that sexual assault, a victim, in this case E. Jean Carroll, could bring in other past incidents where an individual engaged in sexual assault of other individuals, in this case of other women like Natasha Stoynoff and others who Donald Trump sexually assaulted. And Judge Lewis Kaplan, under the rules of evidence, Rule 413 and Rule 415, made a finding that the evidence that Donald Trump lunged at Stoynoff, tried to kiss and grope her, would be relevant as part of Donald Trump's kind of pattern and practice of engaging in that type of behavior as it relates to E. Jean Carroll's civil rape claims against Donald Trump. So that ruling was already made many months ago when the parties filed what are called motions in limine to try to exclude evidence from entering at trial. Well, now on the eve of trial, Joe Tacopina, Donald Trump's lawyer, is trying to argue that the judge should reconsider his order from a few months ago because Tacopina tries to argue that a kiss and that groping is different than a sexual assault, and therefore it would confuse the jury if they were hearing about kissing and groping because that is different than the allegation of a rape. And I'm just going to read from you for some portions of Tacopina's letter to the judge so you can just see for yourself just how vile this is and frankly, how vile Donald Trump is. And then I want to read from you the order that Judge Lewis Kaplan previously made so you can see how disingenuous and how frivolous this motion by Joe Tacopina is. This is what the letter is. It's dated April 22nd, 2023. It says, Your Honor, we write on behalf of defendant Donald Trump to request clarification of Your Honor's March 10th, 2023 memorandum opinion on one issue relating to Natasha Stoynoff's testimony, along with a proposed solution to an evidentiary issue. You will recall that Ms. Stoynoff testified in her deposition that defendant Donald Trump escorted her into a room and then grabbed her shoulders and pushed her against a wall and started kissing kissing her. Then someone allegedly came into the room and the incident ceased. Defendant's motion in limine, Donald Trump's motion in limine, sought to exclude this testimony under Federal Rule of Evidence 413D. Your Honor denied our motion. However, we request clarification with a proposed solution. Let me just pause there. Judge Kaplan's order was very clear. It doesn't need clarification. Let me go on and continue reading the letter. Your Honor correctly observed that Trump, according to Ms. Stoynoff, did not touch Ms. Stoynoff's genitals. Also, Your Honor correctly observed that defendants merely kissing Ms. Stoynoff, according to Ms. Stoynoff, would not satisfy Rule 413D. In other words, it would not necessarily mean a sexual assault. Your Honor did, however, note Ms. Stoynoff's testimony that defendant lied when he denied groping her, which perhaps implied that he did grope her. However, Your Honor correctly observed that the portion of Ms. Stoynoff's deposition testimony does not specify what part of her anatomy she claims Mr. Trump groped or attempted to grope. Your Honor then observed that if Ms. Stoynoff's account of the parts of her body that Mr. Trump allegedly touched were the only relevant evidence, it would be debatable whether that conduct alone would satisfy Rule 413D and 415. In other words, would that constitute a sexual assault? Your Honor then performed additional analysis of other evidence which might be suggestive of a plan by defendant Donald Trump to go further towards touching Ms. Stoynoff's private parts, and thus denied the motion in limine to exclude the testimony of Ms. Stoynoff. And then Donald Trump's lawyer writes, Tacopina writes, upon further reflection, we believe that there exists a true threshold issue of exactly what parts of Ms. Stoynoff's body the defendant actually touched or attempted to touch, according to her. If defendant, according to Ms. Stoynoff, only touched her shoulders and kissed her and never touched or attempted to touch her genitals, then Your Honor's conclusion that such evidence is not enough for her testimony to be allowed should be conclusive. Because the second part of Your Honor's analysis, based on other evidence, seems grounded in the uncertainty of whether defendant Donald Trump actually, quote, groped Ms. Stoynoff, we propose that before Ms. Stoynoff is allowed to testify, that defendant's counsel ask her a few questions outside of the presence of the jury. And there's more, but that's basically the same thing. So what they are alleging is that Donald Trump, acting without the consent of Ms. Stoynoff, grabbed her, groped her, and then tried to kiss her. Donald Trump wants the judge to say, as a matter of law, that doesn't constitute sexual assault. I mean, just how disgusting of an argument is that to even make right there? But that's the letter that you're reading it for yourself that they're making to the judge. Let me just pull open, though, just so you can see it, what the judge's previous order was when the judge made a ruling that was, to me, quite clear. And this order, after the motions, I think, were filed back in February, I think this order is from March 10th of 2023. And this is what the judge says about Natasha Stoynoff. Ms. Stoynoff, then a writer for People magazine, traveled to Mar-a-Lago, Mr. Trump's residence in Florida, to interview him and his wife, Melania. Mr. Trump offered to show Ms. Stoynoff a painting that he said was hanging in a certain room and took her there. As she began looking around, she heard him close the door behind her. Then she testified, quote, I turned around and he's right there. And he grabs my shoulders and he pushes me against the wall and starts kissing me. Question, did he say anything before? Answer, not that I recall. Question, and what was going through your mind when Donald Trump did this? Answer, complete shock. Thank you. Complete shock because it was very fast. I was taken by surprise. Question, and do you recall how you reacted? Answer, I do recall pushing him back twice. I recall trying to say something, but not really being able to. I was so flustered. Question, and when you pushed him back the first time, do you recall how Donald Trump reacted? Answer, yes. He just came toward me again. Question. And what about after the second time? Answer. He started coming toward me again, but then someone came into the room. Question. Do you recall who came into the room? Answer. Yes, it was the butler. Question. And did you see the butler have any reaction to what Mr. Trump was doing? Answer. Yes, I did. Question. And how would you describe that? Well, all I know is that when I looked at his face, to me, he had a look on his face like, thank God I got in here, like he's done this before, like he knew that he saw a shut door and he had to get in there. That's my perception of his. Then later in the deposition, she testified. Question. Is there a particular piece of the video that you're referring to? Answer. Lying. This is a video of Donald Trump saying that he never groped her and giving press statements at his rallies saying that she's a liar. Answer. Lying about never groping or kissing women without their consent and how he had the utmost respect for women. Question. You consider what he did to you lying and groping women without their consent? Answer. I consider that he lied about kissing and groping me without consent. The court goes on to say, Ms. Stoynoff's deposition presents a different factual situation than Ms. Leeds. Nevertheless, the legal analysis is similar. Ms. Leeds was a woman who was on a flight with Donald Trump, I think going back from Dallas, or going to Dallas, but Dallas to New York, and Donald Trump tried to grab her genitals on the airplane, and she managed to get away. And Miss Leeds will be testifying at E. Jean Carroll's case at all. The court goes on to then give the analysis where the court says, first, under Florida law, to establish an attempt to commit a specific intent crime, the state must prove a specific intent to commit the crime and an overt act toward the commission of the crime. It is a crime under Florida law to actually and intentionally to touch or strike another person against the will of the other. This clearly covers Mr. Trump's alleged kissing and groping of Ms. Stoynoff, as Mr. Trump tacitly concedes. Rule 415, therefore, is satisfied if Mr. Trump's conduct included an overt act towards the commission of a state crime, 2, taken for the purpose of committing a state crime involving contact without consent between any part of Mr. Trump's body and Ms. Stoynoff's genitals or anus. Second, in the alternative, Florida makes it a crime for a person 18 or older to commit sexual battery upon a person 18 or older without their consent. In the process, does not use physical force or violence likely to cause serious personal injury. Florida law defines sexual battery as oral, anal, or female genital penetration by or union with a sexual organ of another, or the anal or female genital penetration or another by any other object, and the definition makes no mention of intent at all. For a crime that does not have an intent requirement, attempt under Florida law requires the defendant to commit any act towards the commission of such a crime, but fails in the perpetration or is intercepted or prevented from the execution thereof. Then the court just says, Ms. Stoynoff described Mr. Trump kissing her without her consent and against her will. That alone would not satisfy any part of Rule 413D, but Ms. Stoynoff, however, testified also that Mr. Trump was lying when he denied groping her without her consent. In other words, that he groped her. The word groped in the context of human contact means to touch or fondle a person or part of the body clumsily or forcibly for one's sexual gratification. And while groping anyone without consent is sexual misconduct and colloquially what might be referred to as sexual assault, Rule 413 is not that broad. And then the court goes on to say it defines sexual assault as unwanted contact or attempted unwanted contact only with particular parts of the anatomy. The portion of Ms. Stoynoff's deposition now before the court does not specify what part of her anatomy she claims that Mr. Trump groped or attempted to grope. And in Ms. Stoynoff's account of the parts of her body that Mr. Trump allegedly touched were the only relevant evidence, it would be debatable whether the conduct alone would satisfy the rules. As an initial matter, the circumstances of the alleged encounter are relevant. Mr. Trump, she says, invited Ms. Stoynoff, who was at Mar-a-Lago, to interview Mr. Trump and his wife to an unoccupied room and close the door behind her. Actions indicative of a desire for privacy. She went on to say that he immediately and without her consent began kissing her and pressed on as she resisted his advances. These actions are suggestive of a plan formed before Mr. Trump invited Ms. Stoynoff to the unoccupied room and closed the door behind her to take advantage of that privacy and to do so without regard to Ms. Stoynoff's wishes. Moreover, the Access Hollywood tape and the testimony of Ms. Leeds are additional actual evidence that a jury would be entitled to consider in deciding whether to infer that the ultimate goal of Mr. Trump's alleged actions with Ms. Stoynoff was to bring his hands or other parts of his anatomy into contact with Ms. Stoynoff's most private parts. So what the judge is saying is, although Donald Trump has not committed the act or completed the commission, his intent of what he was going to do can be inferred from the circumstances at issue, as well as from the Access Hollywood tape where he bragged about kissing and sexually assaulting women, and from the other sexual assaults that he engaged in. So for the judge, the circumstantial evidence makes it clear. The judge really wasn't confused about the answer. The judge said the circumstances made it clear. So I think ultimately the judge is going to deny this request by Tacopina. But I don't want to lose sight with all of the legalese here that we're talking about somebody in Donald Trump who is the leader of the modern day Republican Party. Right? This is the individual who Republicans want to give the nuclear codes back to. This is the person who the Republicans want to make decisions over your family, your health, our nation, the world, and you have his lawyer arguing that this is Donald Trump's lawyer arguing that merely groping, grabbing, because Trump never finalized the rape and never actually made contact with Stoynoff's genitals, that therefore she should not be considered a victim of an attempted sexual assault. Setting aside what the judge rules, let's be very clear what even Trump's argument is, how despicable that is, and which should just be completely and utterly disqualifying from any job. Yet Republicans want to give him the most important one. Are you kidding me? And by the way, there's multiple reporting by CBS and others in the past that there were 6 friends and colleagues of Stoynoff corroborated her account. She told people at the time in 2005 when it happened, at that time she was afraid to come forward with it because she believed that she'd be destroyed and her career would end. But she had told about 6 people contemporaneously. Look, folks, this case is going to trial. We'll keep you updated on what the results are, but just another disgusting motion by Donald Trump's lawyers. I'm Ben Meiselas. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your incredible support. Hit subscribe. Check us out at patreon.com/MeidasTouch. Become a member there, patreon.com/MeidasTouch. And also, wherever you get your audio podcasts, subscribe to the MeidasTouch podcast. All right, thanks for watching. Hit subscribe on our YouTube channel.
Lock him up! Indictment season is upon us. Celebrate with the new Indictment season t-shirt and v-neck exclusively at store.MeidasTouch.com.